Getting really weird with the Supreme Court. There is a new case that is making its way. It just got out of the Fifth Circuit Court to the Supreme Court that could legalize domestic abuse, or at least legalize domestic abusers having guns. This is amazing. This all goes back to Clarence Thomas. In 1922, in the New York State Rifle versus Pistol Association versus Bruin, sometimes referred to as the Bruin decision. This was the most recent gun decision from the Supreme Court last year. Basically, the reason why they said everybody can have guns, struck down several state laws, gun control laws, was because having guns and not having gun laws was, and I'm quoting from Thomas's decision, consistent with the nation's historical tradition of firearm regulation. In other words, if we didn't have gun laws back in 1789 when the Constitution was ratified, then we can't have them now, basically. So this standard, this is now called the Thomas Standard. If something wasn't a law back in 1789, it shouldn't be a law now. And this standard was just used by the Fifth Circuit Court. There was a fellow by the name of Zaki Rahimi, excuse me, and his wife had a, going back to 2020, 3-year-old protective order preventing him from stalking her or harassing her and her child. And because he had a history of violence, it prevented him from owning a firearm. In December 20 and 2021, he had been involved in 5 shootings. 5. He had shot at 5 people. He sold narcotics to someone, then fired into their residence. He got into a car accident, shot at the other driver, fled, returned to the scene, and shot at another driver's car. He shot at a police officer's vehicle. He fired into the air after his friend's credit card was declined in a restaurant. This guy. So his girlfriend goes to court and says, please stop him from stalking me and take away his gun. He appeals. It goes to the Fifth Circuit Court, and the Fifth Circuit Court says you got to give him his gun back because there were no laws in 1789 saying that women could be protected from men with guns. Because in 1789, women were legally the property of their husbands. And this case now is going to go before the Supreme Court. The Fifth Circuit Court said that Justice Thomas's decision in the Bruin case, quote, forecloses any such analysis, in other words, saying that he can't have a gun, in favor of a historical analogical inquiry into the scope of the allowable burden on Second Amendment rights. Through that lens, we conclude that the law's ban on possession of firearms is an outlier that our ancestors never would have accepted. Well, that's interesting. Does this mean we end our anti-slavery laws? Does this mean that we end our child labor? Well, 2 states have already done that. This is bizarre. I mean, this is an extension of that reasoning of Russell Kirk that I was telling you about. That if it wasn't, if the middle class gets too large, it's a danger to America. That we need classes and orders, which is the phrase Russell Kirk used in his book. He was quoting Edmund Burke. Edmund Burke, who Thomas Paine wrote an entire book against. The Rights of Man was his book. He wrote it because he spent 2 weeks at Edmund Burke's castle on his way to France to get arrested in the French Revolution. Got so pissed off at Burke, he wrote a book. That's what's driving Republican ideology.
You're listening to the Thom Hartmann Program. Call 202-808-9925.
And has been since the end of the Eisenhower administration. It's amazing.